I have my mug here. I got 2 kids. I am the very best dad.
The world's greatest dad.
Well, I don't know how official any of these rankings really are.
And today we're going to talk about the liability implications of having those children. Put another way, can I sue a baby? So what is in many regards, the leading case on some of this subject is a case called Dunn v. Teddy. It's a PA Superior Court case from, I believe it's 1980. So the question here was a plaintiff was injured in a situation where it was like 2 kids hitting each other with sticks, right? And the question is, hey, the plaintiff here who got injured, are they contributorily negligent because they were playing this game? They were hitting the other children and so on. Can you sue a child for negligence? There is applicable case law on this. Pennsylvania's courts have set up essentially a 3-tiered system when it comes to suing a child and asserting their negligence. If the child is younger than 7, a baby, anyone up to and through the age of 6, that child is what we call presumptively incapable of an act of negligence. Like mentally, they don't have the mental capacity to be negligent because they can't appreciate the risk of their action. They can't foresee the likelihood of harm to someone else. We don't usually think in civil terms about like a culpable mental state or mens rea, but it's baked into our civil system in a different way, but similarly to how it's baked into the criminal system. And obviously, you're not going to criminally charge a 5-year-old. Similarly, our courts have decided that if you're from 0 to 6, there is an irrebuttable, it's a conclusive presumption that you are not capable of negligence, and so you can't be sued for negligence, right? So if the 5-year-old hits me with a car that they stole or hits me with a baseball bat in the dugout, I cannot sue the 5-year-old. Now, once you cross to the age of 7, things shift. It now becomes a rebuttable presumption instead of a conclusive presumption. And the difference there is the court will start from a baseline that says any child from 7 to 14 doesn't have the judgment and the rational capability of being negligent. But it's rebuttable. A plaintiff who's been injured by a child who falls into that range can try to put in evidence of the child's behavior, sophistication, character, like mental capabilities that can serve to convince someone to overcome that presumption, right? If you can put enough evidence forth that that child is capable of harboring the mental state of negligence, then you could sue that child. And though it reads like a strict 3-part test, right? Hey, 0 to 6, you can't be negligent. 7 to 14, you are presumed not to be negligent, but it's rebuttable. And then from 15 on, you are presumed to be as capable of negligence as an adult. Though that too is rebuttable, it's just now the burden has shifted to the child. The child has to prove, hey, I'm actually 16 years old, but not